Keeping your business healthy in today's marketplace can be a challenging and overwhelming task. From the threat of litigation inside and outside your organization and the inefficiencies that can rob your bottom line as a result of unproven marketing programs, the deck can be stacked against you. To get ahead of these challenges and stay ahead of your competition, the Bottled Business Sense Show provides practical business solutions that uniquely emphasize key legal principles, management techniques, and marketing strategies to protect and ensure the longevity of your business. You'll learn how to implement marketing and protection principles equal to those used by today's most successful corporations. Join your hosts Bill Bernard, Rick Moscoso, and Steve Smith for some high-energy discussion that will inspire you to take control of your business so it can prosper in today's consistently challenging business environment.
Well, good morning, everyone. I'm Rick Moscoso here on the Bottled Business Sense Show. Today is Tuesday at 10 a.m. at our regular time, and I want to welcome all of our guests and all of our returning viewers here to the show. We are a show that really offers advice or best practices tips, probably is a better way to describe it, to our business owners based on marketing trends, marketing information, coaching information, as well as legal tips and legal things that we should be conscious of to run a better and more efficient business. So we give all this stuff for free. It's a great discussion that myself and my co-hosts share with our following, and we love to do it. We've been doing it now for almost 2 years, coming up on 2 years, and we just appreciate the input from all of you fans out there that have given us some direction as to some of the topics of discussion that you like to hear. So you're always welcome to send in that information. If there is specifically a topic that's business coaching, marketing, or even legal related to your small business, please feel free to send that in to us at bottledbusinesssenseshow@gmail.com. Or if you'd like to be a guest as well, please send in that inquiry. We are on social media, on Google+, Facebook, and Twitter. You can go ahead to those platforms and search for us, as well as for those audio people out there that just love to hear this information just on audio. We are on blogtalkradio.com/Bottled Business Sense Show, as well as our simulcast as you're seeing us here today. So with that being said, welcome again. I want to bring on our legal aficionado and co-host, Mr. Bill Bernard. How you doing today, Bill?
I'm doing great, Rick. Great introduction, and again, we're glad to have everybody here today to, as you said, provide the protection and expertise necessary to keep your business floating along and to be protected and prosperous. And that's, as you said, much better than I. We do that. That's what we do here in a nutshell. We as any good lawyer will tell you, there's no black and white in the law. There's usually gray areas, and so we're going to address we're going to have our first two-part show beginning today, and we're going to continue with the second part of this next week. But it's a very important show because it deals with employee benefits, and we've actually called this show the Employee Benefit Law Primer, and it's going to be part one today and part two next week, and it's going to deal with all of the intricacies that an employee must know, but also, and very importantly, just as importantly, what an employer must know in order to comply with all of the benefits that the California law allows an employee to have. And in that regard, there's a whole array of subjects that deal with this primer. So that's why we decided to, in order to make it a little more succinct, but yet as comprehensive as possible within the time allotted, we decided to do it in two parts. And that's what we're going to do today. So keep in mind that there are always little nuances that are involved in each of these categories. We've got about 10 categories to go through. We're going to do 5 on this show, 5 next week. So if there's anything that you need to follow up on, please contact me or another lawyer of your choice, because obviously in a 20-minute to a 45-minute show, whatever it ends up being, we can't present every factual scenario that may arise. So these are general ideas and topics that you need to know pursuant to California law. So I thought, Rick, what we'd do is we'd start out in this primer about employee benefits by just addressing some of the very basic things up front. And the first category that we'll address is appropriately called basic facts for employee benefits. And one of the things that I always seem to get a question about, believe it or not, out of the whole array of important stuff that an employee needs to know, I oftentimes get the question, can I be reimbursed for my mileage? I got 2 questions on that just last week, believe it or not. And of course, the answer is yes, but an employee must know that we're talking about expenses for travel, dining, and mileage other than to and from work. You're not going to get reimbursed for any mileage when you travel from your home to your workplace. And the important thing to remember is that an employee cannot agree to waive his right for reimbursement. This is California law. So your employer can't entertain a discussion with you and get you to waive this right that you have. And of course, I don't know if everybody knows this now, but the IRS currently has the reimbursement for mileage at 56 cents per mile. So that's the first important basic point that I want to discuss. Get that out of the way. It's pretty straightforward. The second one is, how many hours does an employee have to be work to be considered full-time? Well, part-time status is determined solely by your employer. Your employer determines what is or is not part-time status, and of course, then that then dictates what would be full-time status, right? So part-time status can be either more than 32 hours per week in the most typical circumstances, and some employers actually say anything less than 40 hours is part-time. So employers generally take 2 directions. If you work 32 hours or more, you're full-time. Oh, and by the way, employer B says if you work less than 40 hours, you're part-time. So it depends on the employer, but remember, the employer can choose to set part-time status at his or her own ledger.
So that's not a hard and fast rule that there's everything under 40 is part-time, or everything like you had said. And
right.
And is that I know we're talking about California, but is that true as a general rule across the country?
Well, it's true as a general rule as long as you follow your state law. I couldn't tell you across the country what every state law is. I can tell you in California that an employer has the right to decide what's part-time. Now, typically, again, out there, you usually will find most employers either saying 32 and above is full-time, or 40 or below, under 40 would be part-time. They're going to, generally speaking, they take one of those 2 routes. Another important issue, I think, for our viewers and listeners to remember is that an employee can be forced to work 7 days a week. The Fair Labor and Standards Act, which we'll talk a lot about, called the FLSA, provides that, does not limit, I should say, the number of hours per day or per week an adult employee can be required to work. So what does that mean? It means that if you initially agree to work 5 days a week and your employer unilaterally decides to increase your work schedule to 7 days a week, hoping you may quit, that could be considered or deemed a termination, and you might have a cause of action for wrongful discharge. So up front, the employer is going to tell you, give you notice, if you will, of what your work week is going to consist of. Now, when you go to get the job, can the employer say your job is going to consist of 7 days a week? Yes, he or she can. And then you decide whether you want the job or not. So once your work week is determined, the employer can't up the hours without your agreement in order to get you to do certain things that he or she may want you to do. In some circumstances, that may be to quit your job, right?
Mm-hmm. Yeah.
So that's an important factor to remember. So remember your mileage reimbursement, your full-time hours, your 7 days or 5 days a week or whatever it is. These are important little topics that an employee should know going into the job. You want to know this stuff going in. You want to question your employer. Hey, what's the circumstances? Do I get reimbursed for my mileage? and how much. Of course, you're going to have to get reimbursed if you're going to have mileage on your job. But you may also say, hey, I get the travel, I get dining expenses, right? And of course, what's the IRS rule for mileage? Do you follow that? You better follow it if you're the employer. How many hours are going to be in my work week? How many hours am I going to be considered part-time or full-time? And am I going to work 5 days a week or 7 days a week? Another issue, of course, is the California minimum wage law, and that takes us into our second area. The California minimum wage law is required in California, of course, as in most other states, because it's a federal law. And up until January 2016, it was $9 per hour. It's now $10 per hour in California and across the country. So remember, however, that some employers are required to pay more than the state minimum wage. Why? Because certain cities and local jurisdictions have what they call local living wage ordinances, which means that if you work in San Francisco, for example, they may have a higher wage, minimum wage law that says if you work in San Francisco, you got to be paid $11.13 an hour, at least, at the minimum, not the federal $10 an hour. So you're always going to be paid the federal minimum wage, which is now $10 an hour, but you may have local ordinances in certain jurisdictions that you work in that require you to be paid more than the federal minimum wage. Importantly, I get asked from time to time, Rick, whether an employee may agree to work for less than the minimum wage. In other words, do you want a job so badly, or is your employer just holding this over your head to where, hey, you want this job, buddy? Here's what I'm going to pay you. Will you agree? You know, they kind of hide it and they disguise it in like a will you agree kind of a question. Mm-hmm. Well, the answer is no. No, that's not negotiable. That's California law. You cannot agree to work for less than the minimum wage. So understand this now. There's a federal minimum wage law, but also in California, there's a law that says you cannot even negotiate with a prospective employee to work for less than the minimum wage. So there are some exceptions, and I'm going to name them off real quickly. If you're an outside salesperson paid on commission, if you're an apprentice in a particular job, and if you're the parent, spouse, or child of the employer, well, then you can agree to work for less than the minimum wage. So there are a few exceptions. Interesting, because now you wonder, well, if that's the case, what about tips? And boy, oh boy, do we get this question a lot in the restaurant business, right?
Mm-hmm. Yep.
Well, an employer may not use an employee's tips and credit it toward the obligation to pay minimum wage. That's separate. So if an employee makes, $100 a night in tips, that cannot be counted into the minimum wage that they're paid per hour. And then a question I just got yesterday, what can I do? And really, these questions in the past few weeks prompted this show, really. What can I do if my employer terminates me because I asked why I wasn't paid the minimum wage? Well, now what have you got? A potential discrimination or retaliation suit, and you can file a potential discrimination or retaliation claim. Why, Rick? Because when would you think a question like that may be posed? I'm terminating you. I asked why I wasn't paid the minimum wage, and now I'm terminated. Well, what would be some instances where somebody's paid a minimum wage? It might be somebody who's older. It might be somebody who's of another race or creed, right? Mm-hmm. It might be a female as opposed to a male. So you would have a retaliation claim as well as a potential discrimination claim. But either way, you're going to have a claim with the California Department of Labor because you are being asked to work for less than the minimum wage. That's a no-no. Okay, so we covered some of the basics and some of the minimum wage.
So,
I want to now go ahead.
Before you go on, Bill. So if you've had this happen in the past, or like in your case, you had somebody that came to you and they had been working for under the minimum wage.
Say they have been working for the minimum wage.
Is that what you were saying? You were just dealing with a situation where somebody was dealing with the minimum wage, and then they were
asked they said, hey, I'm not being paid the minimum wage. Why am I not being paid the minimum wage? And the employer terminates that person as a result.
So then their course of action is like you said.
You've got several potential causes of action. You've got retaliation, number one.
Mm-hmm.
You got a possible discrimination claim, depending upon whether you're in a protected class and you're being discriminated against, like race, color, creed, religion, age. And of course, you also have a claim with the California Labor Board for not being paid the minimum wage.
Yeah.
So it comes up quite frequently, Rick, and I think it's important for employees to know this. But again, I want to emphasize it's also very important for employers to be aware of this stuff. In fact, employers have to place in a conspicuous place in their place of business a poster that has all of these laws on it, both federal and state, for purposes of compliance. So the employee knows what his or her rights are. The third area I wanted to touch upon, Rick, is California overtime laws. This gets quite complicated. But one thing I should mention at the top is that if you have a business outside of California, but you send in your employees to do a job in California, you have to make sure that that person gets overtime while that person is working in California, even though that person may be working in California on a temporary basis. So that's important, because now what? You've expanded this, right? Now these employers who are outside the state better know what's going on inside California, right? Or they're going to have a claim on their hands.
Yeah.
So here's what I'm going to recite this just once, and I'm going to ask that our people call in if they want a better explanation, because this gets a little complicated. But let me give you an idea. For each hour worked over 8 hours in a single workday, you're entitled to time and a half. Okay? Number two, for each hour worked over 40 hours in a single work week, you're entitled to time and a half. The first 8 hours worked on the seventh day of a work week in a particular work week is okay. California law requires overtime pay for the first 8 hours worked on the seventh day of a work week in a particular work week. Okay, so you've got these scenarios moving and grooving, right? I call it in and out. So remember, time and a half every hour over 8 hours in a single day. Time and a half for every hour over 40 in a work week. And time and a half for the first 8 hours worked on any seventh day of a work week, the seventh consecutive day. Now, what about double time? Well, you get double time for each hour worked over 12 hours in a single day, and each hour worked over 8 hours on the seventh consecutive day of a work week. It makes sense to me. I've got it in my head. I understand it perfectly, but employees may not. So that's why I urge people to take notes during these programs. But again, remember, you're dealing with over 8 hours in a regular day. You're dealing with over 40 hours in a regular work week. And then when you get to the seventh consecutive day, you're paid time and a half for that seventh day. If you go over 8 hours on that seventh day, you get double time. Okay? These are important facts because people get ripped off all the time. They're not paid overtime in the appropriate manner. And then what happens? Well, we're going to tell you what happens in our second part of the show next week. Okay? Yeah, you have to look like you had something on your mind. Go ahead.
No, I'm just saying it's like it as closely as I'm following you, it is very complex. It's like saying, hey, you get paid overtime on the third day of every month that ends with a R, or so make sure to reach out to somebody
on Tuesday.
Yeah, except for Tuesday. Yeah, make sure to reach out to Bill or an attorney so you fully understand the situation, because like Bill said, it can be very complex, and you don't want to miss out on what you're entitled to, right?
But the bottom line is, if you're a non-exempt employee, meaning if you're an hourly employee, you are entitled to overtime. That's the point we really want to drive home. Mm-hmm. And you're going to have to know what that overtime is, what you're entitled to, because if you don't get it, now the employer is in deep, deep trouble. And of course, you have the right to bring a claim. If an employee works unauthorized overtime, is the employer obligated to pay for it? Yes. So if you work overtime and you're not authorized to work overtime, you're not going to be one of your boss's favorite employees. And he's going to say, if you do this again, I'm going to terminate you. But that has nothing to do with the fact that he's got to pay you for that overtime, even though he didn't authorize it, he or she. There are some circumstances where even if you're an exempt employee, a salaried employee, you can get overtime, because typically you can't. You're salaried, you get a certain salary, right? You don't keep track of your hours you work, and you get paid a certain amount each month. If your job description and your job duties, and this is way above what I really want to get into on the show, but if suffice it to say, if your job duties don't match up with what would be considered an exempt or salaried employee, you could claim that you're entitled to overtime pay. So you need to be very specific with your employee when that person is an exempt or salaried employee. That person better have a good understanding of what his or her job functions are.
Now, for me, Bill, that's the first time I've heard of that. What type of? Can you give me an example of what kind of position that might run into something like that, or that type of situation?
Well, let's say you've got a certain job description that you're supposed to do, but you start doing some tasks that are typically assigned to. These are generalities that are typically assigned to hourly wage earners. You may be able to claim that that's outside of what your job description is, and therefore, since you spend time doing that because you were asked to, you're entitled to overtime pay. That's going to depend on what job description is going on with respect to what employee at what job site, right?
I see.
That's where you're going to have an attorney to take a look and say, wait a minute, I should have gotten overtime for this, but I didn't. So, you're a salesperson and you're traveling around the country, and you come into the office one day and the boss says, this is an extreme example, but it drives the point home. Boss says, hey, can you go down the basement and repair our air conditioning? It's not working good, and I know that you used to be a great engineer and you can help us out. Well, that's not what you're hired to do. So you might be able to claim overtime for that kind of a situation. What about where an employee wants to waive his or her right to overtime? Hey, you know what? I'm such a good employee, I'll work 12 hours a day for you, and I won't even ask for any extra pay. Can't do it. California Labor Code says you cannot do it. Don't entertain such a suggestion from any employee at any time. Now, there are certain computer professionals. We ought to ask our friend Kenny Rubin about this, because computer professionals are not entitled to overtime pay under certain circumstances. If they do system analysis or computer hardware design or software design, those types of individuals would be exempt from overtime pay if they make at least $79,050 a year. So that gets a little, this is a very reserved area for computer IT people. So if you're a computer IT person, you need to familiarize yourself with the overtime laws and whether they're applicable to you.
So aside from the computer guys, it seems a little counterintuitive for an employee to even entertain or even ask to be paid standard rate when they're working overtime. Why would they do that? Or what situation might that arise from?
Why, where a computer guy is working, a computer guy might want overtime?
No. Outside of a computer guy, you're saying that an employee cannot ask for, he can't ask for to not be paid overtime when he's actually working overtime. Is that's what you said before the example, correct?
Oh, I gave an example of a computer IT guy, but you're talking about an example I gave previous to that?
Yeah, I thought you said in general that asking to not be paid for is not appropriate, right? So it seems a little counterintuitive for an employee to ask for that. I mean, why would they? I guess number one, why would they do that?
No, not at all, Rick. Actually, it's very, very happens all the time. An employee needs a job. An employee approaches the employer, a potential employee, and says, "You know what? I'll get a leg up on getting this job because I'll tell the guy that I won't be paid. I'll work more than 8 hours a day for him and not be paid overtime. He'll hire me versus Joe Blow because I'm willing to waive overtime."
Okay, so now I understand. So from a leveraging to get the job standpoint,
sure,
yeah, okay.
Yeah, or to get special treatment after you have the job. Hey, by the way, Mr. Boss, I don't need overtime. Thinking the boss will favor you or look favorably upon you, something like that.
I see. Mm-hmm.
What about if you're an independent contractor? Well, no, you're not entitled to overtime pay. Obviously, you're not an employee. But if you're misclassified, and this happens so often where employers misclassify their employees as independent contractors. And of course, we did a whole show on that some time ago. You can go back and look in our archives where we discussed the characteristics of an employee versus an independent contractor. So an employer is responsible for this. If the employer misclassifies this individual and says he's an independent contractor when really he or she is an employee, now you're running into problems because now you've got to take into account all of the California labor laws that are applicable to employees. And just because you misclassify the person doesn't let you out of those being in compliance with those laws. How about number 4, which is our California law on meal and rest periods? An employer must provide each employee with a 30-minute uninterrupted off-duty meal period for every work period that exceeds 5 hours. Okay? So if you're working over 5 hours a day, you've got to have at least a 30-minute meal period. Okay. Also, in addition to that, California employers must provide each employee with a 10-minute rest period for every 4 hours worked. All right. So if you work at least 4 hours, you got to have a 10-minute rest break every 4 hours. And for every 5 hours you work, you got to have a 30-minute meal break. That's important because many times it turns out, Rick, again, there's 2 scenarios here. Not only are they not given it, but they ask to waive it. Hey, I'll work through lunch, boss. No problem, man. I'll work right through lunch. I'll show you what kind of employee I am. Got to be careful of that stuff. And that leads me into this next subtopic here. Can the employer require an employee to work through lunch? Waive the lunch period so I can what, Rick? What's the typical thing here? Why would you want to waive lunch? What would be one of the reasons you would want to waive lunch?
Oh, so they can get out of work earlier, right?
Yeah, absolutely. Can't do it. Now, if you want to let your employee go early, God bless you. But you can't base it on the waiver of a meal period. No. And here's the big one that comes up all the time. Can my boss require me to stay on the premises during my 30-minute meal period? Sure can. As long as what? One big thing. I can require you, Rick, to stay on the premises if you're my employee and photograph me all day in 16, 17 different outfits if I want you to. As long as what?
It's 30 minutes, right?
Nope.
No?
Can't do it. I can't do it because I haven't relieved you of your work duties. The criteria for me requiring you to stay on the premises during your lunch break or 30-minute meal period is that I relieve you of all of your duties. Okay?
So are you saying that employee can leave the premises or cannot?
the employee always has the right to leave the premises unless the employer refuses or says you can't leave. But if the employer says you can't leave, you have to be able to stay on the premises without working. In other words, you're entitled to that 30-minute rest break, right? Mm-hmm. The employer may want you there. She may have an eye on that clock, man, and come, 12:30, bingo, you're back at work. So, Mr. Moscoso, I can force you to stay on the premises during your meal break, but I cannot force you to work. Yeah. You've got to have your free time. And then what happens if the employee fails to take their required meal break? Well, the employee is entitled to 1 additional hour of regular pay for each day the employee worked, at least 6 hours that day. Okay? So let's back it up and make it simple. For each hour that you're entitled to a meal break, for each day that you're entitled to a meal break, and you don't get a meal break, you're entitled to 1 additional hour of regular pay for each of those days. So for 7 days you weren't entitled to a meal break, you're entitled to 1 additional hour of regular pay for each one of those days. And that takes us into the final section for this first part of our show. California law is dealing with pay days and pay periods. This is really important because above all that we've discussed so far today, Rick, one of the principal questions I always get is, do I have to be paid when I'm terminated? Do I have to be paid when I quit? And when do I get my last check? In California, let's start out with the first part of it about pay days. California, when you're a non-exempt employee, when you're an hourly employee, you must be paid your wages at least twice a month. So the employer is required to establish a regular pay day for that, right?
Right.
But an employer may opt to pay on a weekly, bi-weekly, or semi-monthly basis. Okay? As long as it's set in stone as to when that's going to take place. But what happens if you leave your job? What's the situation? Well, when you leave your job, if you are terminated, you must be paid immediately upon termination, that day, that day that you're terminated. If you give 72 hours notice and you quit your job, you must be paid on that day you leave. If you give 72 hours notice when you quit your job and you don't stay the 72 hours, then the employer can pay you your final check within 72 hours. Okay? So you got some ifs, ands, or buts there, but they're pretty straightforward. You're terminated, you're paid immediately. You quit, you give 72 hours notice, and you work your 72 hours, you're paid at the end of your 72 hours immediately. You give 72 hours notice, you quit your job, but you don't stay 72 hours. From the time you leave, the employer has 72 hours to pay your final check. And finally, what about an employee who fails to submit a timesheet if you're required to do so? Does the employer still have to pay wages? Yes. Yes. You have to comply with all of the laws that we have been talking about, even if you're required to fill out a timesheet and you don't. So what happens to the employee who fails to fill out the timesheet? Well, eventually the employee is going to get written up and terminated if he or she continues to violate the company policy, right? Mm-hmm. So that's where we're at. I want to recap real quick for our listeners and viewers. This isn't the juiciest course in the world because we're not talking about discrimination or Michael Kors products or what's on sale at Safeway. We're talking about your rights and your obligations as an employee and an employer. So the basic facts, remember about reimbursement for mileage, how many hours you have to work to be full-time or part-time, how you get overtime if you work a certain amount of hours per day or per week, What about the minimum wage and what the minimum wage laws are? $10. However, they may be specifically higher in certain locales within your community. Remember about overtime laws, when you're required to be paid overtime and how much, and double time. Remember the information we discussed about California meal breaks and rest periods. And finally, remember how we ended the show today talking about pay days and pay periods and when you're required to receive your last check. These are 5 big categories that have many people end up before the California Labor Board and sometimes in court because of violations. And boy, the penalties are steep. They are steep. So next week, we're going to discuss, Rick, payroll deductions. What are you going to be able to take for payroll deductions? You need to know that, Mr. and Mrs. Employer, and so do you, Mr. or Ms. Employee. We're going to also talk about California holiday and vacation pay. We're going to speak about the payment of final wages, which we touched a little bit upon today, and collecting unpaid wages. What do you have to do? How do you do it? And then finally, we're going to talk about how do you deal with undocumented workers. That's important stuff for our undocumented workers to know. Real important for them, but it's also real important for employers to know.
Yeah.
So tune in for that next week when we present employee benefit law part 2.
All right. Well, great. Thank you very much, Bill, for the first half of this topic. It's very interesting. It's very important, obviously, for employees to be knowledgeable about, as well as employers. And so if you fall into one of these situations, please reach out to Bill. His contact information is below this video, but why don't you go ahead and share it with us before we sign off here this morning, Bill?
Sure, absolutely. Bill at wfblegalconsulting.com. You can visit my website, obviously, at wfblegalconsulting.com. My numbers are both 949 area code. One is 413-6535, and that connects directly with me. And then the business phone is 698 but I'm having a senior moment here. 698-6222. There we go.
All right. Well, great. Thank you, everyone, for joining us for part 1 of this episode of Employee Benefit Law Primer, part 1. Join us again, same time, same place, for part 2 of this episode, and Bill will continue on our discussion here and fill you in more detail with the topics that are upcoming next week. So with that, everyone, have a great day, have a great prosperous day, have a prosperous week, and we will see you again right here, same place, same time, on the Bottle Business Sense Show.
Take care, everybody.